Who's the person identified as Kiana?
She just said she's the victim.
Yeah, it might be the victim on Jada Otis. She is on the hall, but
The victim on which?
Jada Otis. Just wanted to watch from my conference room. I've already spoken with her this morning.
On the record in the matter of the people of the state of Michigan versus Jamie Castellano, file number 24-02286. Appearance, please.
Morning, Your Honor. Case Markarian appearing on behalf of the people. First, making a motion to practice under Michigan Court Rule number 8.120.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Castellano, who is returning to the courtroom at council table right now.
Mr. Castellano.
Is the date set for final pretrial. The matter is scheduled for jury trial October 22nd at 8 o'clock in the morning. Are we continuing to trial?
Your Honor, at this time, the necessary witness, Lisa Winnie, has failed to appear. The people are unable to proceed. Our office had made contact with her at one point, but I tried to contact her again yesterday. That's just going to voicemail.
Thank you, Your Honor. Given that, I would make a motion to dismiss.
Motion to dismiss is granted without prejudice. The people have the right to reissue this against you. You understand that, Mr. Castellano?
Do you understand that you dismiss without prejudice?
You're talking to me.
I understand.
Okay, do you have any questions? We'll get you a copy of your dismissal in just a moment. Any additional matters for the record?
People.
Nothing further, Your Honor. Thank you.
Record in the matter of the people of the state of Michigan versus Robert Hart, file number 2B-0356. Council appearance.
Morning, Your Honor. Case Markarian appearing on behalf.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Hart, who's standing to my right.
Okay, Mr. Hart, you had a final pretrial today. Matter was set because there was going to be screening for mental health court. Did we get an update on that?
Your Honor, at this time, we're not considering mental health court. However, I think Mr. Markarian has some request for the court.
Yes, Your Honor. I would be requesting an adjourned final pretrial on this, a one-time good cause adjournment if we can. I spoke to the necessary witness, Kalimba Kasoga, on this one yesterday. She did not get a subpoena in the mail. After checking the file, it appears our office inadvertently subpoenaed the 4-year-old child that is the victim of the child abuse charge without subpoenaing her mother. She has school drop off and work today, so she was unable to appear this morning.
I don't think I ordered my witnesses to appear. I did not require witnesses.
Perhaps that's why we didn't subpoena the Ms. Kasoga, Your Honor. Not sure if we just want to set it for a jury trial.
Is that what we want, a jury trial?
Yeah, I don't know if Mr. Markarian has gotten to fully speak with the individual. He made me aware that he'd be seeking an adjournment yesterday, and we weren't going to be objecting to it. So I don't know if the court does want to just set the final pretrial so we can fully talk with the mother about this case, or.
We did speak yesterday, Your Honor. She's still interested in the mental health court resolution and proceeding to this case.
He doesn't want to do mental health court, so what does he want to do?
Well, Your Honor, the mental health court had kind of been removed from the conversation between attorneys as well. There was still a seeking of mental health treatment, I think. If we were going to go back on the track of mental health court, we would need time for that petition as well, since that had been removed from the conversation.
So I'm confused. I thought that was the offer from the beginning. It was mental health court.
Yes, Your Honor, that was my understanding as well.
So is he accepting or declining that? Because I thought you said today that he was not interested.
Your Honor, it had been removed from the conversation. So what I discussed with Mr. Markarian was that he had wanted a second final pretrial so he could communicate with his folks. That would have been the extent of our conversation, sir.
Okay, I recognize that. What does that have to do with, does he want mental health court or not?
You may have a minute to speak with Mr. Hart.
Thank you. Okay, Mr. Rowley, which matter do you have?
We have Susanna and
Susanna, and what was the other one?
Troy Nance.
On the record in the matter of the people of the state of Michigan versus Troy Nance, 23-03436, council appearance.
Morning, Your Honor. Case Mark Aaron appearing on behalf of the people.
Jacob Riley on behalf of Mr. Nance.
Mr. Nance is not in jail. Okay, let's see, Mr. Nance, is your final pretrial one count of domestic violence. Are we proceeding to trial on this?
No, Your Honor. At this time, the necessary witness, Danette Nance, has failed to appear. The people are unable to proceed. If I may make a record, Your Honor.
No.
So attempted to contact the victim, Danette Nance, on this case several times. Based on the number of times I tried to contact her and what happened when I tried to, I assumed her number was out of service. I resorted to emailing her. I did just get an email back this morning, Your Honor, from her saying that she lives over 3 hours away and she has bad signal. She also said that she was not interested in this case proceeding and she would like it dismissed. I've informed her of the process of what a dismissal without prejudice means.
Mr. Rowley.
Defense to the motion to dismiss at this time. Your
Dismissal without prejudice is granted. The people do have the right to reissue this charge against you. Do you understand that, sir?
Yes.
Do you have any questions for the court?
No, ma'am.
We'll get you a copy of the dismissal in just a moment. People of the state of Michigan versus Andre Susana, 24-02259, appearance please.
Morning, Your Honor. Case Mark Aaron appearing on behalf of the people.
Jacob Riley on behalf of Mr. Susanna.
This is the final pretrial, aggravated domestic and child abuse. Do we have witnesses here?
No, Your Honor, we do not. People are unable to proceed at this time. If I may make a record.
No.
I attempted to contact the witness, Amanda Susana, on this case. We did have contact once early on when this was set for a pretrial. Ever since then, and based on that contact, it was my understanding she did not want to participate or appear. I've left several voicemails attempting to contact.
Counsel,
The defense motion to dismiss.
motion to dismiss is granted, but without prejudice, so the people can reissue this against you, okay?
Yeah.
You have questions?
No, ma'am.
Okay.
One question.
Yes,
Can I get this?
you absolutely can. You'll go back down to Ingham County and they'll remove it from you, okay?
Thank you, ma'am.
You're welcome. Any additional matters, counsel?
No, Your Honor.
No, Your Honor.
Hang tight so we can get you a copy of your dismissal, okay?
Thank you, ma'am.
One moment to speak with Ms. Sutter on Robert.
Well, is anybody else ready to go?
Thank you, Your Honor. I'm ready to proceed.
Mr. Raleigh, did you have anybody else?
I know you.
Ms. Jada Otis
Is anybody else waiting for their court?
Oh, this is.
Okay, on the record in the matter of the people of the state of Michigan versus Jada Otis, 24-02219, appearance please.
Your Honor, case Mark Aaron appearing on behalf of the
Good morning, Your Honor. Assistant Public Defender Lauren Sutter standing in for Assistant Public Defender Luke Goodrich on behalf of Ms. Otis, who is standing to my right.
Okay, Ms. Otis has a final pretrial today for weapons carrying concealed and assault with a deadly weapon. We proceed.
Your Honor, there should have been an amended
Oh, one
complaint on that one.
off the record. Computer shut down. I do see that there was amended though.
Pleasure.
Thank you.
Okay, back on the record in the matter of Jada Otis, and this is actually a final pretrial for amended complaint assault and battery.
Yes, sir.
How are we proceeding?
I believe we're setting it for jury trial, Your Honor. The necessary witness, Kiana Smith, is both on Zoom and physically in the building.
I have spoken with Mr. Goodrich as well as briefly with Ms. Otis, and that is also my understanding.
Oh, so jury trial scheduled for October 15th at 8 AM in person at the court. That's so,
It should be, I didn't change anything.
okay, sounds good. Any questions?
There you go.
Okay, did you need another notice to appear, ma'am?
Yes, please.
Okay, we'll get you a notice to appear. Back on the record in the matter of the people of the state of Michigan. Actually, you needed to speak to him, is that correct?
We had
We
a
just
chance to
talked.
brief.
Back on the record, people of the state of Michigan versus Robert Hart, 23-00356. How are we proceeding with this?
Thank you, Your Honor. I have spoken with Mr. Hart. I've also spoken again with Mr. Markarian. At this point, Mr. Hart is interested in mental health court. We would be seeking an adjournment so we can get that petition or the application filed.
For another final trial.
We can do a final pretrial, and I was gonna think about it. It's a few weeks to a month for a screening. 30 days.
October 22nd at 8.
October 22nd, 8 AM.
Thank you, Your Honor.
Do you have any questions today, Mr. Hart?
No, Your Honor.
Okay, additional matters for the record.
Your Honor, do we need witnesses to appear for that
No
one?
witnesses will be required to appear.
You said they will?
They will
Will
not.
not. Okay. And then I just wanted to make a record, Your Honor. The offer on this one has been updated. So long as Mr. Hart completes mental health court successfully, we will dismiss the charges.
That's also my understanding. I appreciate that being put on the record.
Noted. We'll get you a copy of your notice to appear and you'll be all set for today, okay?
Thank you, Your Honor.
They're gonna be Alan, Christopher Williams, but I'm not sure if Jules on the record or Casey.
Say Williams should be a plea to, Your Honor. Was reset.
Christopher Williams is still free covering in the.
Yeah.
Okay. She did that. Just bring up. One slot.
Yeah.
On the record in the matter of the people of the state of Michigan versus Isaiah Williams, 24-01944. Council appearance.
Good morning, Your Honor. Case Mark Aaron appearing on behalf of the people.
Jacob Brown, on behalf of Mr. Williams.
Okay, today's the date and the time scheduled for a jury trial. My understanding is there's a plea.
Yes, Your Honor.
Yes, sir, and I have the paperwork.
Okay, the offer is for the defendant to plea as charged. No objection to 769.4A. This was the offer at the final pretrial. Why didn't we do that then?
Your Honor, the attorney for Mr. Williams, have we considered since the final trial?
That's the reason why we hold the final pretrial. So you can have the offer considered, you can see if there's interested parties and not unduly tie up court time. Same offer. Was there restitution?
No, Your Honor. I have no request for restitution on that one.
You want to accept the offer? I can't hear you.
Yes.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Thank you. Domestic violence is a misdemeanor. Maximum sentence is 93 days in jail and or $500 in fines. You have the right to have a jury trial. And you have the right to the presumption of innocence at your jury trial. So it means you're innocent until proven guilty. You have the right to require the prosecution prove your guilt at trial by proving each element of the charge being brought against you beyond a reasonable doubt. You can remain silent at trial and not have silence be used against you. You can waive the silence and testify at your trial if you like. You have the right to subpoena witnesses to trial to testify for you and present evidence at trial that you believe show a defense to this charge. And then you have the right to see, hear, and question any other witnesses that the prosecution is calling to testify against you. You understand each of those rights?
Yes.
You want to give those rights up today? This is your signature?
Yes.
Okay. Anybody threatening you to get you to give those rights up? Has there been any promises extended to you that enticed you to give up your rights?
No.
Are you currently on probation or on parole?
No.
Do you understand that a guilty plea could result in a conviction that you may need to report to your current employer or you may need to report it to a future employer?
Yes.
You also understand that a guilty plea could have impact on where you can travel or get immigration.
Yes.
That's the charge of domestic violence. How do you plead?
Guilty.
Are you pleading guilty because you believe you're guilty?
Yes.
Factual basis.
Your Honor. Mr. Williams, on June 27th of 2024, we present at the location 1143 Dorchester, apartment 11, City of Lansing.
Yes.
Can you agree that is in the City of Lansing, Aingham County, State of Michigan?
Yep.
Was a person named Cassandra Williams also present at that place and time?
Yes.
And Cassandra is somebody you have a relationship with, in fact, you're married, correct?
Yep.
What happened on that date, that location that would make you guilty of assault?
So we got into it early in the morning as soon as I woke up, and she was on the phone with a couple people on a video call, and I was already irritated with her, and I went to go try to smack the phone out of her hand because she was on the phone, and then that resulted in her turning and getting smacked. So that's what started the whole altercation.
So to be clear, you physically went to slap her hand to get the phone out of her hand. And that was the initial physical.
Yeah.
And you were not acting in self-defense at that time.
Yeah.
I believe that's a factual basis.
Any questions from the prosecution?
No, Your Honor, the people are satisfied with the factual basis.
Court says on the factual basis, I'll accept your plea if finding you made freely, voluntarily, and intelligently. I think this is your law student?
No.
Where do you work?
I work at a Subway.
I get what it says that, okay. You need to meet with probation, I'm gonna have your matter set for sentencing. November 12th at 9 a.m. is your sentencing date. You need to meet with probation, so when you leave here, you need to go down 1 floor to the 5th floor. Checking with probation, they're gonna get you prepared for a pre-sentence interview. They're going to give me a recommendation as to whether or not you are even eligible to be on 76924A, okay? You have any questions at this time?
Then you said what floor do I have to go to?
The 5th floor, we're gonna have you escorted down there. Okay. Again, your hearing is November 12th, 9 o'clock in the morning. Any additional matters for the record?
Nothing from the people.
Nothing from the defense, Your Honor.
You're all set, sir. On the record, in the matter of the people of the state of Michigan versus Christopher Williams, 24-02596, counsel appearance.
Morning, Your Honor, case mark hearing appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter, appearing today on behalf of Mr. Williams, who is joining us via Polycom today.
So set for a bond show cause. I was trying to figure out why, but I think I said it's bond show cause. I had no place to release him. Okay. Let's see. Today was the date set for pretrial, but I do see that the people are moving to dismiss because the defendant is incompetent and not restorable.
Yes, Your Honor, if I may make a record.
No.
Your Honor, defendant on this case, Christopher Williams, he had a case in August of 2023 that was dismissed based on a report that we now have in our possession and for this file, deeming that he was incompetent and non-restorable regardless of any course of treatment. APA Martinez has spoken with the manager of the community mental health home as well as Mr. Williams' guardian on Zoom. I believe he's still speaking with them again now to let them know about the dismissal. This seemed to be a resolution that all parties were on board with. So for those reasons and the competency issues, the people are moving to dismiss.
Who is the guardian? Are they just be on Zoom?
Catherine Jacobs is his guardian. I think she might be in a breakout room with Mr. Martinez. She has been on.
She must have left. There was no one in the
I think he's just on the back.
She was on Zoom with me, Judge, just now, but she's logged off.
Okay, sounds good. Okay, matter is dismissed without prejudice. Any additional matters for the record?
Nothing further from the people. Thank you.
Nothing further, Your Honor. Thank you.
Thank you. You're all set, Mr. Williams. You can let the officer know. Tell the officer you're done. Yes, tell the officer that you're done. Have an interpreter on a matter.
Yes, Your Honor, we do. Mr. Ray for his sentencing, and he is ready to go.
On the record in the matter of the people of the state of Michigan versus him, Ray, 24-01319. Counsel appearance.
Morning, Your Honor. Case mark hearing appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter, on behalf of Mr. Ray.
Raise your right hand to the interpreter. You solemnly swear or affirm that you will interpret in the matter before the court completely and accurately and not divulge confidential communication, so help you God.
I do.
Okay. Today's the date set for a sentencing. And I do have a pre-sentence report. It was prepared on August 29th. Council, did you get a copy of it?
I will, I was provided a copy this morning that I have reviewed with him.
Any need to make corrections, updates, or deletions?
Yes, Your Honor, there is a correction to the employment section.
Okay, what's that?
Your Honor, he is employed at the Meyer warehouse. However, it is not full-time.
Part-time?
Yes, Your Honor, between 20 and 30 hours a week. He is also concerned that may decrease a little bit next month based on some doctor recommendations concerning a back issue.
Oh, sounds good. That'll be noted. Any other corrections?
Oh, Your Honor,
You can make allocation.
thank you. You know, I have reviewed the interview that Mr. Ray did with probation. I've also reviewed the notes left by his prior attorney. I do believe the recommendation from probation to be a fair and reasonable one. Mr. Ray is obviously concerned about some of the ability to do everything he's asked based on the language barrier. He is willing to do what the court is requiring here and anything he can to repair the situation before him. As we previously noted, he is employed. He does have some medical issues. And he is going to be keeping his probation officer up to date with any important medical updates regarding employment. His only concern regarding probation is housing concerns. However, he has asked for my offices and our social workers assistance in those concerns. Mr. Ray appears to be the person who is trying to step up today and do what's right here and do what's going to be required from the court. Given that, Your Honor, I would ask the court to adopt the recommendation, keeping in mind his potential economic hardship with work hours and possible decrease in work hours for medical issues when assessing fines and costs today. Thank you, Your Honor.
Okay, let's see. I have reviewed the pre-sentence report and recommendation. Does your client want to make a statement at all?
Want to, we don't.
I didn't hear a response on the record.
I do not want to make a statement.
Thank you. Okay, so the recommendation is for a term of probation, granting 769.4A. Officer did have concerns about the language barrier and the ability to find services in the area. And then also alcohol consumption being an underlying issue. I'm gonna adopt the recommendation. Sentence into 6 months probation. While on probation, do not to use, purchase, or possess alcohol, marijuana, or controlled substance without a prescription. You will be required to submit to random preliminary breath test and urinalysis testing. You have to pay the fee for that. You cannot be at any bars or nightclubs. You cannot possess or purchase a firearm, ammunition, or weapon of any kind. Not to engage in any assaultive or threatening behavior. I'm going to continue the no contact order. To Krishna Rang Rai, Samip Rai, and Sanskriti Rai. It's Ray, actually. Okay. And you're to maintain your employment and provide evidence of that to probation. Going to grant 769.4A. And upon successful completion of this term of probation, I'll suspend 92 days of jail time. There's a $30 per month oversight fee that he has to pay to be on probation. $75 cost for crime victim right. $50 state minimum cost. So he has a total fines and cost of $305. He'll make monthly payments on that. Lastly, there is an advice of rights as to probation. It explains that he's been placed on probation at the 54A District Court. And his terms are specifically tailored to address his needs. They would explain how he would make a request for early discharge if he were eligible. He is on probation for domestic violence, so he's not eligible for early discharge. Does he have any questions?
No question.
Okay. You're gonna check in with probation before you leave to make sure they have your accurate contact information while we have the benefit of the interpreter being here, okay?
Regarding my fees and costs, do I have to make the payment today or can I do it?
Nope, you can make it monthly, but you'll start after they give you the terms and conditions for him to sign on.
About 2 months? So I didn't. I don't know.
Any other questions? Any additional matters for the record? You're all set, sir. Ma'am, what's your name?
It's Felicia Jackson.
Oh, okay, she can ask you. Representing Ms. Glasgow.
Ms. Sutter, it should be a plea, Your Honor. She just stepped out to talk to another client on Zoom.
representing Theodore Gomez.
My understanding is that he was still gonna represent himself. I'm not sure if he's ever submitted a discovery request to our office or if he's gotten discovery, but that was what we adjourned for last.
Mr. Gomez, can you start your video, please?
I got it. There we go.
Mr. Gomez, are you representing yourself?
Yeah, I'm
Still,
pro se.
or
Yeah, pro se.
Morning.
Yeah, good morning, Your Honor.
did you get your discovery? Good morning.
No, I haven't gotten it. Was I supposed to request that?
I told you that last time.
No, you didn't tell me
You
that.
I did tell you that on the record. If you're going to request, if you're going to represent yourself, you need to request it. Not only did I tell you, the prosecutor told you.
I didn't remember that. I'm sorry. I'm sorry.
Why is it that you believe that you are qualified to represent yourself if you don't even know that you got to get discovery?
Well, I guess I don't have a good answer for that.
Yeah, operating this way can land you in jail for 93 days. You know that? So
I understand, Your
you
Honor.
could end up with a conviction because you didn't get adequate assistance of counsel.
My apologies.
Well, it's not about apologizing. It's about protecting your rights. And I don't think you're in a position to protect your rights.
I understand.
Is there a particular reason why you wanted to represent yourself?
Well, I thought I could handle it. I am a former candidate for the bar. I went to a law school.
You graduated from which law school, sir?
Well, I didn't graduate. Rutgers University School of Law, class of
Oh,
'83.
you did not graduate from law school?
No,
Okay, so you're not a lawyer.
no, not.
And you don't know that you need to get some discovery. You need to even see what it is that they're using against you. You don't even know what it is.
Well, I don't know how I missed that. Because
Okay. Okay. Are you employed, sir?
I'm retired. I'm a master electrician.
Okay. Okay. And so you still take the position that you want to represent yourself, or did you want to request appointed counsel today or time to hire an attorney?
Well, I guess
It's your option. You can waive counsel if you want, but I don't think it's a good idea.
okay. I can request appointed counsel.
Okay, I'll have an attorney log in to do an intake with you.
All right, thank you.
You're welcome.
Yes, sir. He's not. The thing came back not efficient, so he has to resubmit.
Your Honor, would you like me to speak to Mr. Gomez?
Yes, but you're representing Ms. Jackson?
I think. You want to proceed with her first?
Yes, I'll do it. On the record in the matter of the people of the state of Michigan versus Felicia Jackson, this is file number 23-02951, counsel appearance.
Good morning, Your Honor. Case Mark Aaron is here on behalf of.
Jacob Riley on behalf of Mr. Jackson.
Okay, Ms. Jackson, you have a sentencing today. This was for abandonment cruelty to one animal. A sentence report. It was prepared on the 12th of September. Counsel, you got a copy of that?
Yes, Your Honor.
We need to make corrections, update your deletion.
We have none.
You can make that motion.
All right, do you think the assessments and recommendations of the precinct report are appropriate? Ms. Jackson certainly has learned from this experience. She it's not something that is going to happen again in person of March, and I think she certainly accepts responsibility. She's prepared. Programming might be ordered by probation. So I guess my request would be just that the court follow the recommendations.
Does your client want to make a statement today?
Please.
He's not currently on probation, correct? No, she is on probation.
I just got off of probation.
It says sentenced on April 22nd, 2024 to 12 months probation.
Well, Your Honor, to clarify, I believe that's referring to her co-defendant on this case.
Oh. Got it. She's not on probation. I do see a conviction from on her file recently, but it looks like she got fines and pots. Is that accurate?
I believe that's what.
So I think the officer's concern in this report is the lack of ability to take responsibility or acknowledge the actions by you, Ms. Jackson.
No, I do take all the responsibility. I should have took them to the hospital, right when it happened, regardless if I wasn't able to pay for it right then and there, should have.
It does indicate you were very emotional during the time that you indicated that you would never intentionally hurt your animals. And that the report author didn't believe that you were in a position to take or accept responsibility for the cruelty. So if I were to read this, not considering whatever was put on the record for the factual basis, what I would read here makes me believe that your position, you can tell me if I'm wrong, is that you didn't do any action, you didn't take any action that you believe was cruel toward them, but you believe that your fault was not getting them any help after the action. And what role would the neighbors have played in your mind?
Well, okay, so it was kind of like an ongoing thing with me and the neighbors, the kids were like going off, and me and my stepdaughter, they kept letting them off the leash and kept messing with the dogs.
They kept letting your dog off the leash?
Yes, let them, both of them off the leash. It happened before. And so that's why the neighbors, I think they had. But I should have been watching my dog, considering the fact that this has happened, they had let my dogs off. And they were terrorizing my dog, throwing rocks at me, my stepdaughter, and my dog, and stuff like that. But I should have still went and got them the care that they deserved and needed at the time being.
I think the recommendation is appropriate. I will adopt the recommendation. However, I don't know if 12 months of probation is necessary. So I'll do 6 months probation. While on probation is a $30 per month oversight fee that you're responsible for. I'm starting you off with 6 month probation, but it's up to you. You could get it extended by not following my order. You understand that?
Yes.
You also can earn yourself some jail time, 93 days of jail to be exact, also by not following the court order, okay? While on probation, you have the following requirements. I need you to complete anger management, and you can get information from probation about where you can do that at no cost to you, okay? And then you're also gonna complete the moral recognition program, okay? You are employed still.
Yes.
You're gonna maintain employment and provide evidence of that to
Yes.
probation. I recognize you're on a fixed income. I'm not gonna require you to do alcohol at this time, okay? You're not to engage in assaultive or threatening behavior while you're on probation, and you cannot reside with any animals while on probation. I think you provided proof already of your valid cannabis card. I'm not gonna order you to do drops right now, because you're on a fixed income. And I don't see where this incident was directly correlated by a substance use, so I'm not going to do that oversight at this time. Things to help save you and some finances, and hopefully, I'm sorry,
But I appreciate that.
and hopefully you'll be able to complete this successfully. I want you to focus on the moral recognition so you can get some understanding and some tools about the effects of your behavior, and then some anger management. We could all benefit from anger management, okay? Okay, $75 crime victim right plus a $50 state minimum cost will be assessed. 6 months of probation at $30 per month is $180. The total fines and costs is $305, but you'll make monthly payments on that, okay? You have any questions at this time?
Will they do classes on my days off? I have 2 days off.
You can find out, I don't know when the
Okay.
classes are held, but I'm
Right.
sure that they work around your schedule, or they
Okay.
must have some flexibility, because
That's it.
there's gotta be options, so you can find that out from probation, and when you leave here, you're gonna go downstairs to check in with probation. They didn't provide me with a advice of rights form on here, so you should be having an advice of rights as to probation. Explain that you are being placed on a term of probation before the 54th A District Court, and that you have the right to, can you provide that to her, please? Yes. You have the right to request early discharge once you complete half the original term ordered by the court, so long as you've done all the programming that you were ordered to do and you've not violated within the 90 days preceding that request. You are getting 6 months now, so that means that these first 90 days, if you do what you're supposed to do, you're not violated, you can make a request for early discharge. It tells you how you make that request. If you make the request on your own, you gotta serve a copy on the probation department, which is on the 5th floor of this building, and then you gotta serve a copy on the prosecutor's office. The prosecutor does have 14 days from receipt of your request for early discharge to file any written objection to that request. If I set it for a hearing, then you would have the right to hire an attorney to represent you. Of course, you can represent yourself if you like, but you do not have the right to court-appointed counsel for that hearing, okay? I've not set any of these for a hearing, but I've also not gotten, I don't think I've gotten any objections from prosecuting office too. So if there was an objection, that could trigger a hearing. Nonetheless, we've not been in that situation this time. And so, do you have any questions about your rights and rights, or your fines and costs, or the terms and conditions of your probation? We'll get you downstairs to check in with probation before you leave to make sure they have accurate information. So you need to leave that liquid outside. Any additional matters for the record? Thank you. You're all set. Thank you. Who's representing Ms. Glasgow and Mr. Hickson? If it's Ms. Sutter, she can come. And then Mr. Raleigh, if you want to meet with Mr. Gomez, I appreciate it. Thank you. Okay, on the record in the matter of the people of the state of Michigan versus Shanice Glasgow. 4-02593, council appearance.
Good morning, Your Honor. Case Mark Perrin, appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Ms. Glasgow, who is joining us via Zoom. And Your Honor, may I approach?
Files.
Wow.
There it is. Okay, today was the date set for pre-trial. This was the destruction of a building, domestic relationship. Let's see, was there an offer on this? Ms.
There is.
Glasgow, please start your video.
Yes, Your Honor, there is an offer. There's also a resolution, if I may approach with the plea sheet.
Okay, so the offer is for you to plead guilty to malicious destruction of a building less than 200. It says there's restitution being reserved. Estimated value at this time is 500. And there's a killer rule of no upfront jail. You understand that offer, Ms. Glasgow?
Yes.
You want to accept that offer? Or do you want to proceed to a jury trial?
Can you repeat the offer?
Malicious destruction of a building less than $200. It's a misdemeanor. The maximum penalty is still 93 days in jail and or $500 in fines. And then you would likely have restitution. It looks like it says estimated value of $500, but I don't know if they have restitution amounts at this time.
Don't have the exact amount at this time, Your Honor. There is a potential conflict, it's the victim on this case is also defendant on some other, so I was just waiting to call.
Okay, sounds good. So the restitution is being reserved until the time that they can confirm the amounts, but this looking like an estimated amount of restitution that you would owe for about $500. Could be more, could be less, we don't know yet. But that could be ordered even after a plea. But you still have the right to have a jury trial and require the prosecution prove your guilt. So did you want to have more time to think about your offer?
No.
You want to accept the offer, or do you want to proceed to a trial?
I can accept the offer.
Okay, raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes.
Okay, you can put your hand down. Okay, so in order to accept this offer, I need to understand that you know your rights and that you are willing to give these rights up. First is your right to the presumption of innocence. That means that you are considered innocent and you are to be presumed innocent until proven guilty by the prosecution. They would have to prove each element of the charge of malicious destruction of a building beyond a reasonable doubt at a jury trial. You understand that?
Yes.
You want to give up your right to the presumption of innocence?
Yes.
Okay, you have the right to proceed to jury trial and remain silent at trial and not have silence be used against you. You understand that?
Yes.
You have the right to confront in court and cross-examine or question any other witnesses that they intend to call to testify against you. You have the right to see, hear, or question any witness in trial. You can call your own witnesses or subpoena witnesses to testify for you at trial. You can remain silent at trial. Not have silence be used against you, or you can waive your silence and testify at trial if you like. You understand that?
Yes.
You want to give up all of those rights?
Yes.
Anybody threatening you to give those rights up?
No.
Any promises being extended to you if you give up these rights, ma'am?
No.
Are you currently on probation or on parole?
No.
You understand that by entering a guilty plea, it can result in a conviction that you may need to report to your current or future employer.
Yes.
This also could have impact on what countries you can travel to or where you can get immigration. You understand that?
Yes.
As to the charge or the amended charge of malicious destruction of a building less than 200, how do you plead?
Guilty.
Factual basis.
Thank you. Ms. Glasgow, on or about September 1st of 2024, were you present at 1917 William Street?
Yes.
And is that in the city of Lansing,
Yes.
Bingham County, Michigan?
Yes.
And at that time, did you damage or injure a building?
Yes.
And that was specifically a window and possibly a door frame?
You said a door frame?
Yeah, a window or a door frame of a building.
Yes.
And was that damage valued at $200 or below?
Yes.
Thank you, Your Honor. I believe that satisfies the factual basis.
Any questions from the prosecution?
No, Your Honor, the people are satisfied with the factual basis.
Court is satisfied and I accept your plea and find your plea to be freely, voluntarily, and intelligently made. Matter is scheduled for sentencing November 12th at 9 o'clock in the morning. You need to report to our probation department within 48 hours in person so they can get you set up for a pre-sentence interview, okay?
And Your Honor, if I may just for the record.
Ma'am,
Yes.
Did you hear what I said?
No, I didn't hear.
Exactly. You need to report to pretrial services within 48 hours.
Okay,
I'm sorry, you need report to probation, that is, within 48 hours. They're on the 5th floor of this building, okay?
so I'm on probation.
No, you're not, I've not sentenced you yet. You need to come to our building within 48 hours in person so you can meet with them, because I need a pre-sentence interview scheduled for you, okay?
Okay,
And then they will draft a report that will tell me how they believe you should be sentenced, okay?
okay.
Do you have a question?
Yes, you said go to the probation preliminary trials within 48 hours.
It's the probation department. They're on the 5th floor of City Hall.
Okay, 48 hours.
Yeah, but within the next 2 days. So today's Tuesday. You need to be there no later than Thursday, 10:30.
Okay, thank you.
No problem. Ms. Sutter.
Thank you, Your Honor. I just wanted to say for the record, I would be making a motion for fines and costs for immediate sentencing for Ms. Glasgow with restitution to be left for a hearing. I believe this is a charge that is eligible for immediate sentencing, presumptive fines and costs. She is involved in another case involving the same person as the victim in that case. And I believe this would be a matter of just her making the restitution payments. So I'd ask the court to consider the fines and cost sentencing for her with a restitution hearing being set out as opposed to a sentencing hearing.
We have a victim here.
We do not, Your Honor, but it's based on my review of the file, I don't think this one is one that is Crime Victim Rights Act eligible, so I'll leave it up to your discretion, Judge.
I don't have anything about her criminal history. I have no idea what's going on with her case, so it's gonna be set for sentencing. They give you clearance for criminal history yet?
Yeah, haven't done one yet, but.
Oh, well, they might. The other thing is, if she was in person, I would have moved to immediate sentencing. She's not in person. She's either gonna take her plea in person or sentence in person, one of the two. So she took her sentence, her plea via Zoom. She's talking to somebody right now. She's not even paying attention to half the hearing.
I was sleeping upstairs. I was on the couch. Which put me upstairs.
Yeah. Any additional matters for the record?
Thank you.
Skip children coming. You're all set, ma'am.
Okay, thank you.
You're welcome. On the record in the matter of the people of the state of Michigan versus Tyrion Hickson Jr. 24-02337, council appearance.
Good morning, Your Honor. Case Markarian appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Hickson, who joins us via Zoom.
Okay, Mr. Hickson? Can you hear us?
Yeah, I can hear.
Okay, today's the date and the time scheduled for pre-trial. This was for domestic violence. I think the last hearing, discovery hadn't been exchanged. How are we proceeding?
Thank you, Your Honor. Discovery has been received at this point, and we would be asking for a final pretrial.
Final trial, October 22nd at 8. Jury trial, November 19th at 8.
Final pretrial, October 22nd, 8 AM in person at the court. Jury trial, November 19th, 8 AM in person at the court. Do you have any questions, Mr. Hickson?
Nah, you said no.
Sorry, I couldn't understand what you were saying.
You said in November.
Your final pretrial is gonna be October 22nd, 8 o'clock in the morning. You gotta appear in person here at the court. Then the jury trial is gonna be November 19th at 8 AM, okay?
Okay.
Any other questions, sir?
No.
Is that a no?
Yeah.
Thank you. Any additional matters for the record, counsel?
From the people.
I just have an updated address for Mr. Hickson.
What is that?
It is 552 Isabel Street, Lansing, Michigan. 48910.
His phone number is the same.
His phone number is the same.
He said it was not working before. Is it working now?
I personally haven't tried his phone number. I've communicated with him over email.
Oh, sounds good. I need additional matters, counsel.
Nothing from the people. Thank you.
Nothing further.
You're all set, Mr. Hickson.
Thank you.
You're welcome. Mr. Raleigh, you met with Mr. Gomez.
Yes.
I'll reset his matter.
Thank you.
October 15th at 8:30.
October 15th at 8:30, Mr. Gomez.
October when? Excuse me.
October 15th.
All right, thank you.
You're welcome. You're all set.
Thank you.
Final pretrial or another pretrial? Your Honor?
Just free trial. You requested an attorney. Let's see. Is that Dante Robinson on? Is that who that is?
I'm sorry. Marcel Perez. Robinson is downstairs.
I believe Dante Robinson is downstairs.
Yes,
Okay,
he's
sounds
downstairs. Marcel Carter.
Sounds good. Okay, who do we have here?
Jesse Bridges, Your Honor.
It'll be a no, Your Honor.
On the record in the matter of the people of the state of Michigan versus Jesse Bridges, 23-03409 and 10 council appearances.
Morning, Your Honor. Case Mark Aaron, appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter, on behalf of Mr. Bridges, who is standing to my right.
Okay, Mr. Bridges, you two, no license on dog matters. The people are moving to dismiss.
Yes, Your Honor. We've received proof of a valid license for both of the issues. In this case, we will move to dismiss at this time.
Okay, you're all set, sir. Thank you.
Thank you, Your Honor.
Do we have back here?
Mr. Brown, Jimmy Brown.
On the record in the matter of the people of the state of Michigan versus Jimmy T. Brown, 24-01717, council appearance.
Morning, Your Honor. Case Mark Aaron, appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter, on behalf of Mr. Brown, who is standing to my right.
Mr. Brown, this is a dog license vaccination matter. Council, how are we proceeding on this?
Thank you, Your Honor. Mr. Brown has been working on achieving compliance here. As the court probably aware, money is an issue for him. He is set to go this weekend to get the vaccination for the dog so that he can then go and get the license. We would be asking the court to consider an additional adjournment for him to accomplish that.
You said that I should know that money was an issue, or is he not working?
He is working, he's on kind of limited income. He's just showing me that he was able to get the money today for all of that. He just needs to get to the appointments.
Oh, do you have appointments set, sir?
Yeah, well, Saturday. It was my granddaughter's dog. I moved.
I get all that, but what, you have an appointment Saturday for what?
Yeah, it's at a pet, where you go, buy the pet food and stuff. A doctor comes there, Saturday.
That's to get the vaccination stuff?
Exactly.
And then you gotta go get the license.
Exactly.
Okay. Give me 30 days.
Thank you, Your Honor.
October 22nd at 10.
October 22nd at 10 a.m., okay?
All right, thank you. God bless.
We'll get you a notice to appear before you leave. We'll get you the
Alright.
dates. We're gonna give you paperwork that has a notice to appear. You got a belt on, you can just tie it tight enough and then you don't have to keep pulling your pants up. How about that?
All right.
Thank you. Any additional matters for the record?
Nothing from the people.
Nothing further.
We'll get you your notice. Oh, I didn't see Clifton Brown, Antoine Brock, Sonia Campos, Elizabeth Chiaravali, and Ronald Coxell.
Neither,
All,
one are here.
all failure to pay bench warrant. So wait, Adon Gonzalez is downstairs too.
Yes. Gonzalez, yes.
And Your Honor, I believe that's gonna be in adjournment so we can figure out a global between this case this week and next week.
Okay, Mr. Carter, on the record, people of the state of Michigan versus Marcel Carter, 24-02426. Appearance, please.
Morning, Your Honor. Case Markarian appearing on behalf of the people.
And Jacob Riley on behalf of Mr. Carter.
Mr. Carter must have something else pending, because why does he have a 510% bond on a dog stray?
He does have a few other.
Okay, sounds good. How are we proceeding on this?
We're going to request adjournment of this matter at this time. Carter has a felony case set for exam, I believe on October 4th. There's some possibility of global resolution that might include this case. I would ask that this be resent.
If I may, Your Honor.
Okay.
Mr. Carter is also in the process of having another charge reissued. I can't speak to whether or not it's going to be a felony yet or not. Angela Del Vero is handling that. We just sent a Nolly over this morning so we could reissue that case as well. If you recall, he was set for a pretrial last week where he was told to plead to domestic violence or we would reissue child abuse, potentially felony charges, and that's what we're in the process of doing.
Sounds good. How much time? Mr. Riley?
I believe that felony case was set for exam on October 4th, so I would ask for something after October 4th.
October 15th. October 15th at 10:30. Do you have any questions today, Mr. Carter? Any additional matters for the record, counsel?
Nothing from the people.
Thanks, Ron.
All right, we're all set. Thank you. On the record in the matters of the people of the state of Michigan versus Marshall Weathers, 24-02488 and 24L281492. Council appearances.
Morning, Your Honor. Case Markarian appearing on behalf of the people.
Good morning, Your Honor. Rico Neal appearing on behalf of Mr. Weathers, who is present via the video system.
Okay, let's see. We have one IVAC, OWI, and then a weapons under possession under influence, and then it looks like a CCW disclosure. I knew we reset this because there was another or other pending cases. What's going on with this?
Your Honor, the reason the matters were rescheduled because we had the failure to disclose issue first. The second matter was the OWI. He has been arraigned, and that's how we're now here for both matters.
Was there an offer on this, or how are we proceeding?
Yes, Your Honor. I have not had a chance to communicate with Mr. Neal yet because of the reset. I maybe just asked for a reset pre-trial. I know you've already given one just so we could work out negotiations. Want to do a final pre-trial, I'm sure that would give us time to.
I'll set a second pre-trial.
do October 15th at 10:30.
October 15th at 10:30 work.
October 15th at 10:30, Your Honor. Is that via Zoom as well?
Correct.
Yes, that'll work, Your Honor.
Matters rescheduled to October 15th at 10:30. Any additional matters for the record?
Nothing from the people.
Nothing further, Your Honor. Thank you very much.
You're welcome.
Mr. Weathers, I'll call you shortly.
Sure. It's all confused. Robinson's in custody. He can be brought up.
I did want to note that with regard to Robinson, I think both parties are going to be requesting adjournment. I only mention it now because I don't know if we can sort of waive his appearance without bringing.
Like, that's fine. Let's see. On the record in the matter of the people of the state of Michigan versus Dante Keon Robinson, 23-03626. Appearance, please.
Morning, Your Honor. Case Mark Arian appearing on behalf of the people.
Jacob Riley on behalf of Mr. Robinson, who is in the building but not present in the courtroom.
In custody of the jail at this time. So he's currently lodged in the lockup. This matter was scheduled today for a pretrial on assault and battery, and then there's a bond, a 53 contempt. Hearing that was scheduled for today, but the parties are requesting adjournment for what reason?
Your Honor, Mr. Robinson has a number of new cases, or I should say recently filed cases, including 2 misdemeanors and 1 felony. Felonies set for preliminary exam on September 20th, that would be this Friday. I think there's some possibility that this case, including the pretrial and bond violation, could be rolled into the resolution.
How much time are you looking for?
At least 1 week, frankly, just to get us past that preliminary exam.
Your Honor, if I may.
You may.
I would request maybe a little bit longer regarding the PA 53 on this one, just in case we end up having to run it. Officer Lucas Kilborn, the necessary witness on that, was out with injury. He advised he would need at least a couple weeks to be back on his feet. I don't think it would be much longer than that. And I can work on contacting his partner that was there with him in the meeting. But I'd request maybe at least 2 weeks.
October 1st at 10:30. Any other matters on this file?
No, Your Honor. No, Your Honor.
You're all set. And then Gonzalez, that was going to be an adjournment as well.
Your Honor, if I may, he has a hearing next week as well involving the same parties. There's been a lot of discussion between Mr. McCarrion and I since yesterday. If we were to consider resetting today's hearings to coincide with this hearings next week, we think we're going to wrap this up next week.
Talking about the hearing next week for this one.
Not for this file. He has a separate file that involves the same complaining witness.
It is the under.
24-02680. That's the file I'm talking about, because I have it right here.
Oh, sure. 2680, yes. I have it set for September 24th at 10:30 a.m.
Correct.
This is the free trial. Why are we resetting this? Because he has a free trial next week.
Because there's a couple other things we're trying to work out between the two of us, and we don't think we need to do longer than that. So we were thinking next week, his already set free trial date would be enough time for us to work out what we're working through.
If I may, Your Honor.
Okay.
The underlying facts that resulted in the pretrial set for next Tuesday are also what the violation of PA 53 is for. And speaking with the witness yesterday, she got late notice of her subpoena and would be unable to proceed on that hearing. I also advised pretrial next week. And she seemed to be on board with the plan of just trying to reset them all to the same date if possible.
Scheduled for September 24th at 1:30.
I have 10:30.
Did they change this? 'Cause this was,
I also have
it's, and I'm looking at the note in here. Was this a Judge Ward file and they switched it?
It was.
Yeah, I was gonna say, I just had it set for Judge Ward, nothing. It switched it.
Yeah.
They didn't put any updated information in, not a new notice in here. Okay, let's see, 10:30.
Yeah.
Okay, we'll schedule the other ones. Same thing.
Thank you, Your Honor.
No problem. That's all set. Robinson, that was Gonzalez. I think that's everything.
Yes, Your Honor, that should be it
Until this afternoon.
this afternoon.
Oh, wait. Oh, Mr. Weathers, you're free to go.